prepare for the upgraded experience that is MTN free after one extra. Yes, you heard right. Now let me tell you what the extra is all about. With MTN free after one extra, you can talk for 1 whole hour uninterrupted while paying for only the first minute of every 10 minutes you talk, which means for every 10 minutes you talk within the hour, you only pay for the first minute, and you get to talk for 6 minutes straight, 60 minutes straight, I beg your pardon, with no interruptions. I'm sure you like what you hear, right? Well, as if that's not enough, you get 50 megabytes free data after your first call daily. So you see, now's the time to talk extra with all the people you love. To subscribe to MTN free after one extra today, just dial *550#. That's *550#, and that's how you follow the prompts to enjoy MTN free after one extra. Thank you for staying on State of Affairs with me, Bernice, Abu-Baidoo, Lansah. Today, my guest is Dr. Justice Srem-Sai. He's Deputy Attorney General and Minister for Justice here in Ghana. Grateful for your time this evening. It's a pleasure to have you here.
Yeah, the pleasure is mine. Welcome to my office.
Thank you so much. You appear to be under a lot of pressure. How are you faring?
We are on it. It's okay. It's expected. We knew, myself and my boss, we knew the responsibility that we assumed a few months ago. And we knew it wasn't going to be easy, and clearly it's not easy. And it's going to get even more intense, but we are ready for it.
Do you enjoy your private practice better than this?
I miss private practice. I miss private practice a lot, mainly because of the limited bureaucracy in private practice. Over here, there's so much processes and procedures that we have to follow, and so many people you have to deal with and take so many views into account. It's understandable because the decisions here are far-reaching than private office, so it's also understandable that we need to consult broadly and to take decisions that affect the generality of Ghanaians than a private office where you are just dealing with a few people. So in as much as I miss private practice, I think this is also worth the energy I'm spending on.
Where were you when you received the call or the message, or however the message was conveyed to you that you were up for the position of Deputy AG?
I think I was in Houston. I wasn't in Ghana when I received a call that this is what is coming. So I took a few days off my schedule there and then returned to
Was it
Ghana.
an easy offer to accept?
It was easy to accept, to be honest with you. It was easy to accept because we had worked for power from opposition. And when I say we, I mean there were a very close group of lawyers who were behind the NDC legal team, right from the manifesto through to all the things that you saw about protecting the ballot were all involved. So if you probably would notice, I was actually a polling agent at a point in Legon with other lawyers, and we're protecting the ballot. So we knew that when it was over, you couldn't have brought people from other places to come and execute that which we planned in our manifesto. So I think each of us knew that we're going to be called upon to serve, but the capacity we're not sure. I mean, I wasn't sure which capacity, but when it came, I knew, well, it's something that I had to, respond to, and I did.
During your vetting,
and I'm suffering.
Yes, sorry about that. But your vetting was one of the most interesting to watch. On the lighter side, though, would you have shown us the dance if the chairman of the vetting committee didn't interrupt Afenyo-Makin?
To be honest, I didn't think that Honorable Afenyo-Makin actually expected me to perform the dance. I thought, as of today, I still believe that it was just a question to test my response than to actually expect me to dance. And I'll be very embarrassed for him if he thought that was going to happen. I mean, he couldn't have asked me to honestly, dance the dance there
in that space.
Yeah, in any formal space. I don't think he was expecting that to happen.
Now let's zoom into oral, the big one. There are a lot of conversations about the capacity of this government to prosecute those high-profile cases. In fact, to start with, there are those who question the legitimacy of that oral committee. We were told by Vice Chairman then that we were chasing some $21 million possible money we could recover based on all the entries and the tip-offs that they had received via the website. Are we still standing at that figure? You've done some extensive work now. Is it the same? Are we looking at a higher figure?
Okay, so first of all, people who question the oral committee's work probably didn't understand what the committee was to do. So the beginning of every criminal procedure is complaint. So at the time there were so many complaints of scandals, corruption in high offices, but people lost confidence in the state institutions, because I think over the years they've tried to report some of them to some of the institutions and nothing happened. So they were really looking for a place to lodge those complaints. If the institutions had the trust of the people would have sent their report, these complaints that they sent the committee there. So what the president did within that period was to create a platform for people to lodge those complaints. It was never intended to be an evidence gathering committee. It was never intended to be any official. When I say official, I mean in the criminal procedure we have stages. So it wasn't meant to play any role in the criminal procedure.
But we did see them gathering evidence, didn't we? We saw the committee members going to verify information, see for themselves in some cases.
I like the fact that you said verifying information. Right. So what they were gathering was information.
Right.
And that is different from evidence.
Okay.
So once you get information, so if you go to the police station right now and you say someone has stolen your car, what you have given to the police is information, and we call it complaint. Now the police would have to go and conduct investigations to gather evidence of the allegation of stealing. So what the committee was doing was to gather information. That is why when the president finally assumed office, one of the first official functions he played was to receive the reports, the oral report, which is a compilation of complaints, and hand them over to the Attorney General. So that is when the official criminal proceedings or process would be deemed to have started. And so that is what happened. Now, let me take my time to explain this. The criminal procedure has several steps in it. So the first one, like I said, is the complaint that people make. When they made a complaint, then we conduct investigations. Now, after investigation, that's the second stage. After investigation, the investigative agencies or the investigators would have to bring what we call a docket or investigative report to the Attorney General to now examine. Now, the Attorney General or the prosecutor, we examine these, investigative reports and dockets, and then we identify gaps in them, because the investigators are not necessarily prosecutors, they are not necessarily lawyers. So they give you information. We have found this, we have found a knife, we have found a cutlass, we have found mobile phone. So we will now have to piece this information together and make sure that it forms a seamless line or connection of allegations and evidence that can lead to prosecution. So once they bring the investigative reports, we examine it, and it's a lot of back and forth. So they bring it, we say, no, there's a gap here, go and look for this evidence to fill in this gap. They go again, they bring it, we identify another one. So it's a lot of back and forth. So if you had come here, if you stay here longer, after this interview, I'm going to meet with investigative agencies. They will bring their reports, we examine them, and then we'll tell them to go back to fill in the gap. We do that until we get a docket which we can take to court. Then when you get a docket, that is when you now file charges. So that's another stage. You file the charges, and then after the charges, you go through pre-trial procedures. Then you go through trial. Then after trial, judgment before sentencing. So it's a long process. Now, before you even ask, there's a lot of concern, and I'm very much aware about how fast the oral is moving, the effectiveness of the oral. Is the oral dead? Is it still alive? And let me say this, the oral is alive and is very much on track. Understand the people who are raising those concerns. And indeed, for us, we are happy that Ghanaians are not going to sleep on oral. We are happy that they prompt us every morning on social media. Every day, I receive no less than 100 tags on people saying that there's an allegation of this here, there's an oral issue here, what are we doing? So I am very much aware, and I like it, because when I wake up in the morning, I am energized by the call of Ghanaians to pursue what we promised them. Now, you cannot say at this point that the oral is slow. Do you know why? Because investigations take time. This government, or our government, we are if you compare the time we started going to court on these oral cases with other government, we are about 6 months ahead of any other government. So
some say that's just for the optics. They say you're just doing it because it's populist. You've just admitted that sometimes it takes a long time to build a body of evidence and be able to prefer charges and go to court. So there's that argument of populism being attached, also because the belief is that you want to prove to the people that you're doing something. The minorities, particularly in Parliament, says there's really nothing to chase. In fact, one of the MPs there believes that if you take away the legal vacation, you have just about 26 months left, and he thinks that you can't even prosecute 5 cases successfully.
We accept the challenge. We accept the challenge. But on the issue of whether it is populist, as you can see, the people even think that we are doing far less. If we're going to do populism, I'm sure by now we would have rounded up a whole bunch of people and kept them in remand while doing investigations. There's one thing that is completely different from how we are doing our things and what we know. I'm sure from your work as a journalist, you've heard or you've seen instances where people have been arrested, they take them to court, and for a whole year and more, all the prosecutors do is to tell the court that investigation is ongoing, so they take a date. Investigation is ongoing, they take a date. We have not done that. In fact, we don't even arrest people and take them to court until we are ready and we have filed charges and we have filed our evidence. So, for example, if you take the National Service, we announced that investigations were concluded, I think, somewhere 4 months ago.
Yeah. So
if we're following populism, we would have arrested the long list of people that came out from the investigation and have arraigned them before court, and there's nothing anyone can do about it, because the power to prosecute will be ours, and we'll go to court and be asking the court adjournment, but we didn't do that. We sucked the pressure from the people saying that why are we allowing these people to walk around? And I'm sure you are aware that people, whenever they see some of the accused persons, they get angry. I remember when the lady Gifty was announced as some GFA position. The whole country went, why are we allowing her to even contest? And I'm sure you saw that. And we didn't worry about that because we were not populist. If we were populist, we would have just rounded it up. Right. So the populist accusation is very much unfounded.
Right. Now, on the issue of how much we're chasing, right, I didn't get a response to that. Are we still looking at around $21 million? Are we looking at more? And how much of that is realistically recoverable?
No, so like I indicated, that is information. The evidence we are receiving shows that that amount will not be a fair assessment of what can be recovered. In other words, it is a bit on the high side than what we are receiving from the evidence.
Right. Let's do some specifics now. You received a lot. You have zeroed in. You just spoke specifically about the NSA scandal, but a lot of people are also concerned about the National Cathedral because there were a lot of accusations about perceived corruption, some evidence that was brought into the public domain, especially in the last part of 2024. So how far with the National Cathedral?
the National Cathedral is on. The investigations are ongoing. What we have now is a question of auditing. So we have engaged external auditors who are trying to quantify how much is recoverable. And don't forget that the main issue with the National Cathedral was one of priority. So Ghanaians were angry with that project because it came at a time where things were hard for Ghanaians. People's pension were not being paid. People were being given haircut as we knew it. And then we are building a cathedral. I think that was the main point of anger, but that is not a crime. I mean, it's a government priority. If government says that I'll let the people die and I'll build a cathedral, you can't really charge the government for making that decision. The punishment for that is when you subject yourself to popular elections, they will vote against you, but you cannot bundle a government and say you are building a cathedral.
Are investigations leading anywhere? Do you think that
definitely. Monies were spent which did not get the right or the proper approval, the legal approval. And so that is why I said they are auditing to quantify that amount of money.
And this audit is different from what we already know to be in the public domain?
Yeah, that is different. Like I said, when what we have in the public domain is information generally saying that you have spent this amount of money, but not that whole amount is criminal. A component of it were spent without proper approval. That is what we are trying to ascertain.
That's what you're zeroing in on.
Exactly.
Okay, but there's also the issue of public lands and the sale of public lands. A quick update on that?
Yeah, so on the public land issues, a lot of the lands that the investigation is pointing to the fact that a lot of the lands we have, that are in issue, yes, they were acquired, and I think let's go back to the allegation. The allegation is that they were bought at a ridiculously low price. I think that was the main allegation. Now the question again is the fact that the prices were low themselves will not be criminal in terms of someone committing a crime. What we are looking at is which civil vehicle or mechanism, civil law mechanism, could we use to reverse some of the sales. But that government has sold land to you at a ridiculously low price is not necessarily evidence of a crime for you to prosecute. But we can recover those lands by other civil mechanisms to bring justice to the people. So we are looking at that option.
And on PDS?
PDS, the investigation is still ongoing. And a part of the PDS issue is still under arbitration. Yes, so investigations are ongoing. When crimes are specifically identified, we'll deal with them.
The Abu-Baidoo case seems to be the one that has received a lot of attention in court. And the latest is about the third accused, whose charges have been dropped because she accepted a certain plea bargain. And there are those who have expressed some reservations about plea bargaining. They argue that, look, yes, we spend a lot of time in court, we spend a lot of money prosecuting cases, but also the belief is that engaging in plea bargaining sometimes results in people receiving less punishment for an offense, i.e. justice not being served.
Yes, so when it comes to plea bargaining, we need to understand one thing, that there is a law which regulates plea bargaining. Okay, so plea bargaining is not the invention of one of my boss or myself. It's a law which existed, and I'm sure you remember the is it Ato Asian situation was a plea bargaining that was used. Right. So the plea bargaining law simply gives options that sometimes it's better to recover the money for the accused person to serve a lesser sentence than put the person in jail and lose the money. It also acknowledges the fact that in financial crimes, it is important to get the money and deal with the consequence of sentencing the person. Now, this is the question which I wish to answer. Why would a prosecutor go to bargain with an accused person? There could be a lot of reasons. One is difficulty in proving, the crime. That's one. So, for example, one of the principles we have set so far in engaging accused persons on plea bargaining, which is their right anyway. They have a right to approach us with proposals. We also have a duty to examine the proposal and choose whether we want to settle or not. But one of the factors we consider is, are you bringing to us evidence which we wouldn't have had to prove the case against the other accused persons? That is one. The second one is, are you going to return what you have, agreed to have stolen? So these are the two things that we look at. Are you bringing us the money back? And not all. And two, are you giving us evidence which we didn't have? So even if you are bringing the money back, and you are not bringing us evidence which we do not have, there's no way we are going to agree with you on plea bargaining. And if you are bringing us evidence that we didn't have, and you are not giving us the money, we are still not going to agree with you to settle. So these are the principles that we are operating with. Now, the Abu-Baidoo situation, I don't know if you took your time to read the facts of the case. If you look at the facts of the case, it's simply someone setting up a system to take money from the state, run it through private enterprises, and then the money is lost to the state. Basically, that's what's happening. Now, in this process, there are two people that we considered as what? Accomplices, or people who assisted in the process. One of them is the
third accused.
The third accused, who was, we believe, was facilitating the movement of the money and was on the ground. Now, further investigation after we filed the case, and don't forget, we offered her an opportunity to, give us evidence and return the money, and then we can, kind of settle the matter with her, not just other people. So she decided not to say anything, but midway through the trial, when she saw where the case was going, vis-a-vis the defense that they thought they had, she decided to abandon her initial position and then side with the prosecution. Now, the question you need to ask is, why would she do that? She's doing that because she knows where, she can, being an insider, she knows where this is heading. But in her case, we did not have any evidence of, we didn't find money with her. We didn't find money, even though she was involved, we didn't find money with her. And what we realized was that she was doing something with a certain belief which was not what was happening. So when she discovered what was actually happening, she decided not to side with the side that she was. And we thought that, well, this is someone who can give us, testimonies on how the inside of this runs. And we are not just dealing with this prosecution. We are doing this to also prevent future occurrences of such. And so for someone who has knowledge of how these things were done, when she has not actually, we don't have any evidence of monies being with her, we decided that let's take this side and then let her join our side to testify against the accused person. We were successful today in removing her from the case, and the case continued from where it left off. Today we had our second witness, so we had 3 witnesses in the case. We finished with the first witness today. We are on the second, which we'll finish by next week. And then the next week, we'll be doing the third witness, then we'll close our case. So by the end of November, we are definitely sure that we would have closed our case, and then the defense will open their case. So those who said we are doing populism, and those who said we are not moving fast, I don't know when the last time that you saw a case move within a few months with this speed. And that is how we are prosecuting all the other cases.
On the Abu-Baidoo matter as well, his lawyer lost the case, trying to seek an injunction on what you're doing while a certain appeal is heard. I'm sure you must be excited about that.
Oh no, so we not excited per se, but I was happy that the decision went in our favor, because what was going to happen is if the application was granted for stay of proceedings, if it was granted, what it meant was that we would now sit and not be able to move until the appeal is decided, which usually takes another 1 year. So they were not able to show why, to convince the court that this is a case where the court has to stay proceedings, and we were happy that the judge, upheld our side of the argument.
Let's go back to the NSA scandal, because listening to your boss, the Attorney General, address the nation and give us updates. You get a sense sometimes in his delivery of the shock in what was discovered, and some have said that he sounded as though he was already pronouncing judgment over a matter that was yet to be determined. In analyzing the evidence that you have, if you don't mind sharing, what has been the most shocking or fascinating discovery for you?
No, so the shocking thing is this concept of the markets. So the scheme that it's an elaborate scheme within the NSC, where look at it this way: how much is national service allowance? A meager 700 cedis. So you could never believe that millions of cedis could be siphoned through a project which pays personnel 700 cedis. You thought it's a poverty project. If you listen to national service and what we all know about national service, the suffering we go through, we all knew that it's a place for suffering. Then you are told someone was able to siphon 500 million cedis. That was the shock in it. So it was shocking that you could siphon this amount of money from. And personally, I didn't believe it until I started seeing the evidence. Then I started seeing the movement of money into bank accounts and out of bank accounts, and I was shocked too. Now, the shocking thing is how elaborate and deliberate people could be in designing this kind of scheme to siphon money from public coffers into private pockets. You create a market. So the market is supposed to be a place where national service personnel could buy items that they didn't get in their posting, and then pay by installments
on
over
the
period from their allowances. So this is a brilliant idea. Then we realized that the people set this system up and were pushing a lot of money into the markets when no one actually bought anything. So we're paying huge sums of money to vendors in the market when these vendors sold nothing. And these monies then go around and then enter into private pockets. That is the shocking thing of it. And we believe that when the trial starts, Ghanaians will be able to see how shocking it was. And that is not to say that they are guilty. No, it's only the courts that can say someone is guilty. But when you see what's wrong, you will feel it.
So Gift Owari and Mr. Osei are, in this case, the first two accused. You have just detailed how shocking the evidence is. Is plea bargain on the table for them?
Every Ghanaian is entitled to plea bargain. And they've approached us. Some of the people have approached us to bargain. And so, and we rejected some. And the fact that, some they are in court should tell you that we rejected some of the proposals. Does
that include Gift Owari specifically?
It's without prejudice, so I will not mention them. But I can confirm to you that a lot of them approached us for bargaining. We considered them based on the criteria I mentioned to you. We considered them and we rejected some.
Right. So you estimated about 500 million cedis, and the conversation has come up for a plea bargain, which means most likely that some of the monies are going to be returned, if not all. So with the conversations that have been had so far, how much possible recovery are we looking at?
We really are looking at recovering that amount.
The entire amount?
Yeah, we're looking at, you mentioned 500.
Yeah.
Yeah, you mentioned 500.
500 million cedis.
Yeah, we're looking at recovering that. It's one thing we're looking for that and the people having it to give. And if they don't have it to give, we would trace every single thing that they have, every asset, every property, as far as the law will allow us, we'll recover each and every one of them.
Interesting. You're watching State of Affairs. Today I'm speaking to Dr. Justice Srem-Sai, he's Deputy Attorney General, and we've touched a lot on oral, some of the key cases. We've gotten a quick update on the National Cathedral, which is on the table for many people. We've gotten a quick update also on the National Service Authority scandal. When we come back, we'll be looking into what's happening with regards to Ken Ofori-Atta. Is the Office of the AG keenly working on this with the OSP? I've got that on my table and a lot more. Do stay. you so much for staying here on State of Affairs. We are talking about justice delivery in Ghana, fighting corruption, prosecuting cases, and how far we've come. My guest, Dr. Justice Srem-Sai, is Deputy Attorney General here in Ghana. And before we continue our conversation, have you guys heard the latest from MTN? If not, you have to listen to this. For those of you who love MTN Free After One, prepare for the upgraded experience that is MTN Free After One Extra. Now, let me tell you what the Extra is all about. With MTN Free After One Extra, you can talk for 1 whole hour uninterrupted. Sounds good, right? While paying for only the first minute of every 10 minutes you talk. This means for every 10 minutes you talk within the hour, you only pay for the first minute, and you get to talk 60 minutes straight with no interruptions. I'm sure you like what you hear, right? Well, as if that's not enough, you also get 50 megabytes of data for free after your first call daily. So you see, now it's time to talk extra with all the people you love. So here's what to do. To subscribe, just dial *550#. *550#, and that's how you enjoy MTN Free After One Extra. Thank you so much for inviting us, for having us once again, Dr. Justice Srem-Sai. So we've spoken about Aura. We've touched on many of the cases that a lot of Ghanaians are keenly following. You have assured of fast tracking, if I may say, all these cases, as the president has also hinted at creating some processes to allow for that. Are you able to give us a quick update on that, with the president's intention on prosecuting corrupt officials and public officials, to be precise? He said that there's something in the working with regards to fast tracking the process so that it doesn't have to drag.
Yes, so we have the tribunal system, which we are starting.
You are reintroducing, or this is a different one altogether?
We are activating it. It's actually a constitutional provision. It's
right.
Part of the constitution, and it's something that we're supposed to have been doing. Just that it got to a point where no one was interested in them. So we have decided to revive that, to enforce that part of the constitution by establishing the tribunal system. We believe that, in consonance with the constitutional provision, that justice emanates from the people, and the people's sense of justice must be respected. There is no point pursuing a certain cause of justice which is always shocking to the people. Justice is no justice if the people don't feel that it is justice. And for the people to feel that justice is being done, it is important to involve them in the process. There have been so many instances where single judges or judges alone have decided cases where the people were shocked that we all saw this. How are you telling us the person didn't do it? We all saw this, the person didn't do it. Why are you telling us the person did it? It is a gap between the people's idea of justice and the courts or lawyers' idea of justice. What the tribunal system does is to fuse the people's idea of justice with the lawyer's idea of justice, so that we break that gap. That is simply what the tribunal system is about. And for us, we believe that the tribunal system will fast track the cases that we are pursuing. Other cases will also need specific courts. So, for example, the Galamsey, the president spoke of setting up special courts for the Galamsey issue.
We know that there's such a court in Koforidua, we are told.
Yes, but there is a court there. Usually what the problem is, you can designate a court as Galamsey Court, but when the court is choked with other cases, overwhelmed, you can call it whatever name you call it, the problem will be the same. So what the president spoke of and what the Chief Justice is going to do is to dedicate empty courts to these cases. So, for example, if you go to court today with a Galamsey case, the normal court, the judge has divorce, the judge has cases on armed robbery, he has all manner of cases, and all of them are important. So the judge is not going to stop hearing those cases just to deal with the Galamsey issue. So what we are trying to do is that when we dedicate specific courts to that, then it means that the court's calendar is clear. So if you bring a Galamsey case, the judge will be able to hear it day to day, and then end the proceeding. Just as it happens in the West. If you go to the United States, you hear that someone has committed a crime. Within a few months, they go to court, they hear the matter within days, and the decision is made. There's actually no benefit even to the accused person to be hanged in a justice system for years when you can have your verdict as soon as possible and have appeal. So
let's stay a while on that, because as you speak, I'm beginning to wonder the amount of time we spend on prosecuting cases. Does it really only lie in the court's capacity to pay attention to that case, or prosecutors not coming forth with the evidence, the arguments, closing their cases early enough? Just help us understand why we're really finding ourselves in this really tight situation when it comes to justice delivery.
Yeah, there are a couple of factors. The first one that we often encounter is where the courts are overloaded with different types of cases. So they have to spend time doing all of them, and they all move slowly. That is one. That is what we are trying to address by dedicating empty courts to cases. There's also a problem of the rules of procedure that we use. A lot of jurisdictions don't use the procedure we use now. So in the US, for instance, when you are trying a criminal case, the prosecution will prepare all their cases and file their evidence. Then when the court starts trying the case, it's day to day, then the case is over. In Ghana, and that is one thing that we are not doing. In Ghana, once someone is accused of stealing, we go and arrest the person, we put the person on remand, and then we start taking dates. Every 2 weeks, case adjourned for further investigation, and that runs for a year, sometimes 2 years. We are not doing that. What we are doing is that when we invite you and we start the investigations, we do not keep you in remand. We finish the investigation before we file charges, and then we start hearing. So let me give you a typical example of this. If you look at the Wontumi case, Mr. Wontumi was arrested earlier, and then no one, when we released him, people were complaining, how can you arrest and release the man? Why? The man has destroyed our water bodies and you have allowed him to be walking. Allegedly. Then we allow him to be walking. Now, last week, we charged the man. Within 2 weeks, we are supposed to complete filing our evidence. After that, trial will begin. In the previous regime, what would have happened was that when he was arrested at that time, he would have been kept on remand, and they will now be doing the investigation while it's on remand, and that can take years. So that is the difference. So when you see persons, suspects or accused persons walking around, it doesn't mean that they have come to bribe anybody, or they bribe a judge or bribe the AG or have cut a deal with the AG. It is because we are mixing respect for human rights together with fast and efficient judicial system.
But not all your critics agree that you're respecting his human rights. In fact, some argue that you're using very stringent and very unrealistic bail conditions to keep people. So Wontumi, for example, we know that as at the time the bail conditions were set for him 2 weeks ago, it was almost 4 p.m. He had to spend another night and another, and then and there was another case which required some other bail conditions. And so the argument largely from his lawyers and other critics is that we're using the bail system to punish people unnecessarily.
That cannot be the case, because I have personally had a conversation with his lawyer and even he himself, and he did not, both of them, none of them raised this issue that is being raised.
Mr. Apiakubi, you mean?
Yes.
Oh, we have engaged him. We have him on tape.
Well, I have spoken to him. Even yesterday I spoke to him in the presence of his clients.
Right.
Now, what's the issue here? Bail condition is determined by the courts, right? So we went to court and the court determined the bail condition. Now, for a court to determine the bail condition, the court would have to take into account what amount are we even trying to recover, or what the gravity of the offense is one, whether the person is a flight risk is another, and so on, whether the person is likely to interfere with evidence, whether the person is likely to appear before the court the next time. So when the court is making this decision, it's going to consider if the amount involved is $100 million. If I give bail of 10,000 cedis, the person will pay the money, will leave the money with someone and run away. And what's the essence of the bail? Or if the person is a flight risk and I don't seize the person's passport and ask the person to report very frequently, the person can just disappear. So sometimes maybe education is very important for us to understand. I understand the economic situation, that there's very, people, we don't have the money, the country is hard and all, but we're also trying to secure the presence of the accused person for the trial. And that is why no matter how you look at this bail condition, it won't make a lot of sense if the amount of value or the value involved is $10 million and you are taking bail for 100,000 cedis because the economy is hard. You know, you yourself, the same people will say, why are you leaving this person and he's going around 10 million? They will accuse the judge of even collecting bribe and then letting him go.
On this response, here's what I see, that you're trying to separate your job as a lawyer from what the judge and the courts determine. But listening to some of your own colleagues in some of the reactions from court, especially from the side of Wontumi and his lawyers, the perception that has been created over time is that the lawyers of the government of the day have...
That's the Attorney General's office.
That's the Attorney General's office, has cases determined in their favor. And that's the perception being created out there. And it happened in the previous regime and it's happening now. It brings me to the point of public perception.
This is even inaccurate, because you just told me that we have not even had any case determined yet.
No, I'm not talking about full determination of cases. For example, you go to court and you plead with the judge to remand somebody, for example, or make an argument that the person could be flight risk. Right.
One of our policies is we've never opposed bail in any of these cases. If you follow the record, anytime any accused person applies for bail, we don't oppose bail. It is not part of our philosophy to be opposing bail.
I understand. No, I'm coming to the point of public perception here, and this has nothing to do with...
I'm trying to correct, use your media to correct this public perception. And there's a lot of propaganda in the system. For example, your colleague, were just having a conversation on the fact that they said we appear to like the media. I can tell you, I have never granted interview before, after any of the cases I do. My colleague on the other side grants interview before going to court. When the court is on break, he goes down to grant interview. After the court proceedings, he grants interview again. And then for all the 8 months that we've been in power, my boss has granted 4 interviews. Out of the 4, 2 were not on any specific cases. It was only 2 that were on specific cases. Just 4. Personally, this is the 3rd time I'm having this kind of interview so, and consider the number of press conferences the opposition party have held. The members of the opposition party have held on oral alone.
But that's always the case, though, Justice Srem-Sai. That's always the case. The government of the day...
Why you say always the case? What do you mean?
What I mean is that usually the government of the day hardly runs to the media for anything. It's those in opposition who think that they need the voice.
You should point it out to those who say that we like media. Because with these facts, you cannot still insist that we like media than any other person. Because I just left court. In the morning when I was going, I was begging your media men to just let me pass without talking. And I do that every day. My colleague on the other side is always speaking to the media, and most of the things he said are actually inaccurate. So, in other words, you are trying to gag us and give them a free pass to poison the population.
So you have a choice to speak or not. No one is gagging you.
No, but
that's why you have this platform and opportunity.
If you encourage, I would expect that when they are saying we like the media, you will point to the facts that, look, this is the statistic. These people have granted this number.
But that's their perception. And when they say that you like the media, probably they're talking about your boss coming into the media space, as we have witnessed, to give updates.
I've just given you the number of times my boss has been in the media. I've given you the number of, go and check the number of times he's open. Our opposition people have been in the media with press conferences and all that.
We can go on and on about this. It has to do with perceptions, and it has to do with...
I owe it a duty, just that I think you also do. Your media has, you owe the duty to the people to let them see the fact that... So otherwise, we allow people to use this propaganda. We call it propaganda. So you say every day, the AG likes me that, the AG likes me that, and then nobody's checking the fact. And everybody thinks the AG truly likes me that. But the fact is that as compared to the opposition, we are nowhere. Even in the previous administration, when the Attorney General was prosecuted, every day when he finishes court, he will grant interview. Your colleague was accusing me that these days I don't talk to the media. That is the reality.
Right. Back to the Wontumi case, if you may. So there's a whole conversation about a certain missing docket and it being found and all. Just briefly, if you can, just help us understand how that...
No, what came up was this.
Was established.
When I think it was one of the journalists, the what's his name? The guy who your colleague who does the investigation on
Erastus.
When Erastus first raised this forest reserve mining, there was an initial investigation into the matter. But the investigation didn't see didn't see the light of day. So we all forgot. I don't know whether we forgot or we just got tired of waiting for results, and nothing happened again. So when we came to power, then a different complaint was lodged. It was in the middle of investigating that complaint that it came up that apparently there was a whole investigation into the affairs of Akunta mining in that forest, which was not moved forward, or which got not missing in the sense that it couldn't be found, but it is someone's duty to pursue, justice. The person decided not to pursue this justice and left it there. Now,
was there a reason?
We are still investigating that, and when we would definitely, the person would definitely have to answer why. Maybe the person has good reason to keep it there. We don't know, but the truth of the matter is that there was already an investigation conducted into the matter, and the result was almost to confirm that there was a wrongdoing, there was a criminality which required prosecution.
Right. Talking about things that happened in the past and revisiting and all that brings to mind my own colleague who was a journalist, an investigative one, Ahmed Swali, who tragically lost his life. This year there was an arrest made, and it sent a lot of positive signal even within the media fraternity, because we've been really following this for a long time, only to hear that the case has been discontinued upon the advice of the Attorney General. Just help us understand, did the AG advise for this person's prosecution in the first place, and in hindsight, does the AG think that
the Attorney General or the Attorney General, this office, we did not advise that the case should be discontinued.
What was the advice then?
No, we asked for further investigation. The murder was committed from eyewitnesses by a couple of people.
Sorry, I mean discharged. I beg your pardon. The suspect had to be discharged, and further investigation on the matter was proposed by the AG's office.
Yes,
I'm talking about the suspect in particular now. Did you advise that this person be sent to court, and in hindsight, do you think that you made a mistake on that advice?
This office did not advise that the person be discharged.
What was the advice?
That was not advice. The advice was for further investigation.
And so what has happened to the suspect now?
Yes, so you could put the suspect on bail.
So specifically, I'm asking you, what has happened to that suspect? Because the reportage...
the suspect will be rearrested and because the advice from this office was not to discharge the suspect or to...
But did you see that? Did you see the news that the suspect had been discharged?
Yes, we saw the news, but
we
had our own investigations into the matter.
Right.
We looked at the advice we gave, and there was nowhere in the advice that we asked that the person should be discharged. The advice was a further investigation. Let me explain this to you. At this stage, the person is entirely in the hands of the police service.
Right.
And so what happens when they make arrests? They forward to us docket, and I was explaining that earlier. We look at the dockets, and then we advise that, okay, this person may be of interest, or maybe an accused person, but we need this further evidence to be able to confirm that position. Oh, this person is not really someone we should even arrest in the first place, so let him go. These are all options. In this particular case, the advice was never that the person should be discharged. It was for further investigation. And we assume that as the practice, the police also have their own procedures, because they use our power to prosecute. And we expect them to do certain things. And that is what I think there was a miscommunication along the way. When we are investigating how it came that the person was discharged, we are conducting that investigation.
Okay, so just as a statement of fact here, the person was discharged, and the media did report accurately that the person was discharged. What you are contesting here is that that was not the advice of the Attorney General.
No, this office did not advise.
All right. So once the AG got the notice that this is against our advice, what did you trigger? Beyond the investigation, what else could have been triggered?
What we do is we conduct, because when the news came, we also heard the news. Okay? So that was it was Friday, I think so. So on Monday, the first thing we did was to do our internal checks as to what happened. We are finished with our internal checks. We are looking at the police. We are moving to the police side, what happened with the power. So definitely we'll come to a conclusion. But what we know is that this is not a case where the person could be discharged. It's a case where, at best, the person should be on bail, on police inquiry bail.
And so you're saying on record that he will be rearrested?
Definitely.
Right. Let's talk about Ken Ofori-Atta and the Office of the Special Prosecutor. And I it's an interesting smile you have on your face. But what is happening? I recently saw a photo. Someone suggested that probably an invasion of the privacy of Ken Ofori-Atta, but others argue that he's a wanted man. He's needed back in Ghana. What can you tell us about attempts to get Ken Ofori-Atta back into the country?
Yes, so Mr. Ken Ofori-Atta is a subject of a number of criminal investigations, right? I think the one that is popular is the one that the OSP is conducting. And also, that is the one that we are made to believe is in an advanced stage where extradition will be required. And indeed, the OSP has already put the person on red alerts, Interpol red alerts. What it means is that it's a notice to the whole world that this person is a wanted man. But the Interpol alert is not an extradition, procedure. So if we really want the person to come, we need to make an extradition request to where we believe he is, which is the US. Now, this is what's, and listen to me carefully on this. We are the only authority, that's the Attorney General Office, we are the only authority that can make extradition. But we need a docket from, an investigative docket from the OSP to be able to make these extradition requests. As of today, we still do not have a docket from the OSP. We have made several requests to the OSP, written letters, written demands to the OSP, asking that now that you've announced to the world that you are ready to have this person extradited, and there have been communication to that effect that even we've seen communication to the effect that the docket is ready and it's only the Attorney General that can make the. So we have been asking for the docket for a couple of, I think about 2 months now. We still do not have the dockets from the OSP. And so without the dockets, you cannot go to the American authorities and say, this is the person we want him. No, you need to show, because when they are asking for people to be extradited to the United States, they bring the full docket of, as if they are going to court. And then we take that docket to court for the court to see whether there's really merit for, bringing the person down. We have to do the same thing. We also have to take a full docket of all the evidence and what we believe the law, and then we take it to the United States authorities, and they will process the extradition and bring it. And we have been having communication with the American authorities, and they all of us are just waiting for the docket from the OSP, and then we kickstart the extradition process. Does
it appear to you that there's some feet dragging from the side of the OSP?
I wouldn't call it feet dragging because I don't know what they have found. Whatever you know from the OSP is what I know.
What is the correspondence? You've written, you want the docket. What exactly is the response you get back?
So I won't be able to give you the details of the response, but the broad thing I can say here at this time is that the OSP has informed us that they have not yet completed their docket investigations to be able to hand it over to us. You mentioned earlier that
Mr. Ken Ofori-Atta is under a series of investigations, but the OSP appears to be the most...
Even within the OSP system,
there are a number of... Exactly.
Yeah.
But is your office in particular investigating him for
We don't conduct investigations here. I was explaining to you earlier. We use other people's finished products as our raw material. Right. And the finished product is dockets. So
maybe I should put it this way. Are you aware of any other investigations by any other body besides the OSP on what the...
Oh yes, I'm aware of a BNI investigation, I'm aware of a GHOne investigation, I'm aware of, yeah.
Right, and what's the progress on those investigations, if you are aware?
They are far advanced, and at this point I cannot disclose the details, but they are far advanced. I mean, if not the OSP, in the case of the OSP, he has already disclosed his details, so I'm able to speak to that, but for BNI and the others, they have not publicly, and I think we do not have to disclose that at this point.
Since we are speaking about extraditing, possible extradition, We witnessed something recently in this country, a certain MOU that our Foreign Affairs Minister says was signed between us and the U.S. government, agreeing to accept some deportees into our country, created a lot of buzz. There were concerns about why that did not go through parliamentary approval. We understand that the AG was aware, advised. Can you clarify exactly what happened in this particular matter?
I would not be able to disclose the details of the advice that we have given, but whatever this government did in respect of these the deportees, I don't know whether they are deportees, but whether to call them deportees, this particular issue was done in accordance with law, and we do not need to belabor the point. I'm aware of suits that have been filed by Democracy Hub and other people to challenge that, and we look forward to having that that issue resolved in court. But I can tell you that whatever we did in respect of this issue was done in accordance with law.
But shouldn't this have gone to Parliament?
Shouldn't what exactly?
The MOU that was signed, shouldn't this receive parliamentary oversight at least?
Who said it's an MOU?
Well, that's what we're told.
By?
The Foreign Affairs Minister.
Well, I am not aware of whether it's to call it MOU or not, but just take it from me that whatever we did was in accordance with law. And we are happy that the matter has been sent to court for a determination to be made.
But they are not in the country as we speak. They
are not in the country.
They were sent to Togo. Why didn't we wait for the determination of that legal matter?
No, before those issues, there's no injunction on us.
Right.
We have not been injuncted from deporting anyone. So we do not see why we should. And the fact is that the people were not meant to be in Ghana. It was a transit point for them to go to other places. Do you understand? So,
and I appreciate that, but also people say that, look, they had gone to court. They wanted a matter heard on their behalf. In the spirit of fairness, at least, could you have just given them that opportunity?
No, I mean, I think the legal authorities have been clear on this matter. Unless there is an injunction, we are entitled to continue government business as we plan to.
Right.
And so long as we believe that what we're doing was right and there's no court injunction on us, I do not see the basis for the argument that the people are making that we should have kept them here for what? Waiting. So we should keep them because somebody intends to get an injunction. No, that was not the agreement. That's not the plan we had for them.
Right. So we understand that some of these persons spoke to the BBC and they used the expression of being dumped in Togo. Can you just, if you do know how they were sent there and what the processes were like?
I wish I knew what they meant by dumped in Togo. When you say dumped, I could imagine something like this. But I don't think that's what happened.
Were they given over to Togolese authorities? You just drop them off, for example, at the border? Just, I want to understand if you know what processes were followed through.
I do not know how the allegation of dump or how they introduced dumping people in Togo is like. But we know that these people were in a transit situation here. And their final destinations were, they had various final destinations, and they have been sent to those destinations. As to whether they were, I don't know where dumped in what sense. I'm not sure of that. But
at least you can tell us that their rights as humans were considered in the entire process. Look, you handed them over properly, or you? I just want to understand.
Yeah. So take this from me, okay? President Mahama would never abuse anybody's rights, whether a Ghanaian or a foreigner who is transiting through Ghana. And so if someone is claiming that rights have been abused, we are not saying we are infallible, but to suggest that the president or this government is participating in a human rights abuse project is to miss the whole point, and that cannot happen. And if it happened, I can tell you the president I know we have would do everything it takes to punish whoever was part of that.
So there's a case filed by Democracy Hub at the Supreme Court over this matter. You have mentioned earlier that the decision to allow these deportees to use Ghana as a transit was not illegal.
It was not illegal. It
Yes,
was not bad.
but would you advise that since there's a matter in court over this whole situation, that we hold on, at least if there are any plans to still allow deportees to use Ghana as a transit?
No, we will not hold. Like I said, if there's no injunction on us, because what we did, we believe is right. So it is only when we know what we are doing is wrong that we can stop doing it. So until our position is proven to be wrong, we will continue to do what we believe is right. And if it involves serving as transit points for people, the government would do that.
Interesting. So we've already spoken about the kind of pressure in this work for you, but we haven't spoken about possible pressure from what we usually will refer to as highly influential people in terms of prosecuting cases and having some interventions, our culture, our way of looking at things, pastors, imams, all the levels of interferences that you can talk about.
Well, I am very lucky. I think I sit in a very luxurious position in respect when it comes to this issue, that because everybody knows I'm a deputy and I have no final say in who goes to what and who doesn't go to jail, or who will prosecute or not. So I don't have that situation on my desk. But I know I have a lot of, my boss runs a very open, office with me, and I know that he's not the kind of person that you can even approach to have that kind of conversation. And if you approach him with that kind of conversation to influence him to subvert the law, I know the answer he would give you. And I know my president would not also entertain that kind of conversation. So even though I'm sitting on a very comfortable chair when it comes to this issue of influence, because nobody will come to me, because whatever I say doesn't matter. It's my boss I don't think they are encountering this pressure that you are, and if they are doing it, I'm sure they are rejecting every aspect of it.
The General Secretary of the NDC has been talking about interference into Oral's work. You say that you haven't received any?
I don't think he was talking. He said people were interfering with oral work. What I understood him to be saying is that he is hearing that some people want to come and influence our work. And he was commanding all of us to, or he was directing or suggesting that we resist such attempt. That is how I understood his communication. I didn't hear him say that he saw people, or he's aware that people have come to influence anyone.
You're watching State of Affairs. Today I'm speaking to Deputy Attorney General Dr. Justice Srem-Sai. We'll take a quick breather. When we come back, we'll be talking about more about justice delivery. We'll talk about the state of justice delivery beyond the capital city, Accra. Tonight on State of Affairs, we've been talking every and anything legal, justice delivery, fighting corruption. Justice Srem-Sai is Deputy Attorney General, and I've been having the conversation with him. Thank you so much once again. Now, legal education is such a big topic in Ghana, and quite recently we saw some lawyers being called to the bar in our own Sewa, being part of that really exciting news for a lot of young people in Ghana. But some are also concerned.
And all the other people who were called.
Yeah. Some are also concerned about whether we are not sacrificing quality for quantity when it comes to conversations about expanding legal education. We know that Roxanne Dafiameko is, trying to work out something to allow for a certain major reform within the legal education sector. From where you sit, I know do you still teach though?
Yeah, I'm
still exactly.
That is actually my University of Ghana is still my employer. I'm only on secondment here.
Interesting. So from where you sit, both as an Attorney General and a lecturer, what are your genuine concerns about opening up our legal education, if there are any?
Yeah, so like everyone else, I'm concerned. I'm interested in quality. Quality lawyering in our country. And like many people, I'm also interested in giving opportunities to everyone or a lot of people to become lawyers. And I'm not saying this merely because I even think that I'm not even talking of the need or the lawyer-citizen ratio. That's not what I'm talking about. I believe that people should have the rights or should have the opportunity to do what they like. There is nothing wrong if someone goes to law school and ends up not even practicing law. If all he wants to do is to just have the knowledge or to be called a lawyer and then go on to sell, maybe buy things and sell from China, if that's what the person wants to do, I believe that the person should be given opportunity. That, however, should not mean that we should reduce the standards or lower the quality of who becomes a lawyer. There are issues with our legal education in this country, and the issues have been pending for over a decade. When I was in law school, we were just in a class of, when we're doing the LLB, we're about 100. When we were called to the bar, we were about 180. That was 14 years ago. Now, in a year, we often the main call is about 900,000, and then you have another 500 or so mini call. So the numbers are high. The question then is, how about the facilities? In terms of, and I'm not talking of sitting space as in classroom. I'm talking of the libraries. I'm talking of the moot court rooms. I'm talking of the lecturers, the quality of lecturers. What is their training level? How many years have they practiced to be able to teach? Those are the things we are concerned about. And you cannot have a law school who doesn't have a library. And here I'm not talking of just a physical library, but even online database. Students should have access to that. How many of our law faculties, how many of our law schools have such libraries, either a physical one or even online, where students can just log in and read any material from anywhere? How many of our universities have lecturers who are properly trained and have had that level of education to be able to teach? How many of our lecturers are actually publishing or doing research to enrich the teaching they are doing? How many of our universities are actually, if we are supposed to run a proper check accreditation, So these are questions that we need to answer, and not just focus on the numbers. You can have, when this problem persists, even if you have 10 people graduating, it will still be a question of quality.
So do you believe that we are at a point where we can really expand without shocking the system already, which I get a sense that the questions you're asking are not pointing to a certain positive answer?
Yes, I mean, it's not a positive answer. I'm telling you that we've had this problem of not being ready for the number of students we are producing. And that is why, for example, we are putting in a legislation, a law, to reform the system. So, for example, if you take Ghana School of Law, this is where everyone who wants to be a lawyer would have to come and sit in classroom for 2 years to be able to call to the bar. But they do not have the facilities. They do not have, some of them are actually using universities for their classes. Some of them, I mean, they do not have the requisite number of people who are teaching, and even the quality of the teachers. They need a lot more teachers, and they need people who have experience in either practice or have done research elsewhere.
Sorry, just help me understand. You're talking about the Ghana School of Law here, or the...
I'm talking about Ghana School of Law.
All right.
So they are using, for example, Ghana School of Law is using the facility of GIMPA for their classroom. Some are using the UPSC facility. Some are using KNUST facility. The point we are making is that our reform is going to formalize that situation where we will transfer the training course, which is run in Accra or run by the law school, to the university. So if you go to GHOne, for instance, after your LLB, GHOne will have another program which will be accredited by the Board of Legal Education. So you migrate from your LLB, which is entirely for GHOne to decide.
Right.
Then you apply to join that which should have been happening in the law school. You continue from GHOne. So the law school now will have one exam for people to, so you do not have to come to Makola.
So then what happens to Makola then?
Makola has some facilities.
Right.
And Makola is actually under the Attorney General's office, under this ministry. It's part of it's one of our agencies. And we need places for training for attorneys, investigators. So Makola could still be there, but it will be used for something other than formal, institutionalized legal education. Now, there are other aspects of legal education which Makola can still conduct. We have something called post-call, So those short terms, we could actually convert to judicial training. There are so many things we could do with Makola, but what we are saying is that for coming to Makola to sit in class for 2 years and go through another admission process and all that, we are transferring that to the universities. And we are going to carefully select these universities. It's not as if once you are university running LLB, then you can run the Makola program. So
when you say we, do you still mean that the AG will still be supervising the AG's office?
Precisely.
Right.
The AG's office is will still be responsible for professional legal education. The difference here, however, is that we are not going to run a school for that. We are going to give accreditation to the universities to run that program, and we are going to have a supervisory authority over that program, ensuring that no one is going to be teaching in that school who is not sufficiently qualified. No one is going to run any course which we have not given accreditation to, and no one is going to gain admission to that school unless the person meets a certain standard. And no school, no university is going to run that program, is going to be given accreditation to run that program unless they satisfy certain basic criteria. For example, you must have a library full range library, not just physical library, but also a database, the online database. You are going to have a moot court room, and we are going to have a regular training for lawyers to acquire the skill of advocacy before they graduate. So it's not going to be just business as usual. And we believe that we are putting this in place to ensure that we are not just churning out the numbers, but also the numbers are coming with some quality training.
When it comes to the ratio of Ghanaians to lawyers, we know it's nothing to write home about.
True.
There are very few lawyers who actually decide to work for the state.
Precisely.
As workers under the office of the Attorney General. We have taken time to observe what's happening in offices across the country beyond the crime, and you have a very nice facility here. But when you go to the spaces that some of your and colleagues work in the regions, it can really make you wonder, how they're able to even have the desire to step out and prosecute on behalf of the state. In some cases, they have to provide papers, pens, pay witnesses, and that's a big part of your work, funding witnesses and all that. You, as this government, so you have a research agenda, and it's been replicated in every sector. the Attorney General's Department, and I know that there are many lawyers watching us today all across the country who work for the state, who want to do more, but really find themselves in a very difficult situation. How is your research agenda going to change their workspaces and working conditions?
First of all, let me just say this. Congratulations to all state attorneys, those that are in Ghana, those that are in Accra and elsewhere. When you look at the condition under which these attorneys work and the expectation that we have of them, especially when it comes to fighting corruption, you understand that there are still Ghanaians who are willing and ready to sacrifice for this country. Because imagine someone having gone through the difficulties of going to law school and is posted to a place where he doesn't even have an office. And where he's likely to have an office, he doesn't have computers, and the person is still working and waking up every day. That is a lot of sacrifice for this country. Now, back to the solution to that problem. We have a clear plan for that. For example, there's a plan to construct, Attorney General offices in at least all the regions. Now we have 16 regions. Some of the regions have offices. Some are, they are located in rented apartments, but the plan is to build an office complex for every regional capital, at least, where our people will be. And these offices are going to come with residential facilities for attorneys. But of course, that is a question of money and let me say, a long-term project. So in the interim, what do we do? If you speak with attorneys, and we had a meeting with them, their leadership, a couple of weeks ago, and we were trying to find out what exactly their priorities are. And their priorities is conditions of service. Mm-hmm. And it's very sad if I should tell you how much a state attorney who is 10 years at the bar is receiving. The truth is that we attract young lawyers because the average, the young lawyers who come here earn more than their colleagues in private practice. But then when they rise to 5-10 years, the gap between what they earn when they entered and what they are earning is very negligible. Then their colleagues who were suffering in private practice from the beginning now start making more money. So the attrition rate here is very high because they come here, they gain all the experiences, and trust me, well, this is the biggest law firm in the country anyway. So here you can know so many things if you are ready. So they come here, they acquire all the knowledge and the experience, and then they move to private practice so that they can catch up with the money there. So it's as if we are helping them to learn, establish themselves. Skill. Yeah. So anytime I see someone here who is about 10 years and has over and is still working here, I give the person maximum respect because they have all the opportunity to move out somewhere and make money, but they are still here. But what I can say is that we are really having conversation at that level to reform the salary and condition structure of our attorneys. Currently, they are pegged with the judiciary in a way. So if you are 10 years at the bar, you take something close to, if you are a young attorney, you are considered as a district magistrate, and it's good. But just as the judges also suffer when they get to the middle level, they also suffer. So we are trying to, first of all, decouple ourselves from the judiciary and have a completely different assessment and salary structure for our attorneys.
Beyond the conditions of service, some lawyers are also particularly worried about the open admission somewhat of some lawyers about the Ghana Bar Association being an appendage of the NPP, and concerns about the intrusion of partisan politics into a profession that otherwise was a standard or was the balance of the two. The Attorney General at the just ended the bar conference also really spoke about that passionately. The legal profession is a very respected profession by many people, but it appears that, as it is with almost every sector in this country, we've successfully polarized the legal system. And some lawyers are particularly worried that in the near future, lawyers may not be held on the basis of their professionalism, their expertise, but rather on which side of the pendulum they swing to. How are we addressing that as well?
Yeah, so I'm a member of the Ghana Bar Association, right? And that's the only bar association I belong to. And I had expectations when I was a young person joining the bar and I had expectation of the Ghana Bar. Well, these days the expectations are not being met, as as my boss said at the bar conference. We all have that concern that the bar is appearing to be dealing in matters that do not really even benefit their members. So, for example, let me give you an example of this. I sit here, okay, and a lot of people come here with problems, which I know should have been sent to a private law firm. So I had a visitor here who wanted me to go and represent them to have their the body of their deceased mother released from court. And I was asking, why wouldn't you go for a private? Because that's not what we do. These people come here with private problems because of one thing. They do not believe that private lawyers can solve their problem, not because they don't believe that private lawyers don't know the law. They believe in power solving the problem, political power solving the problem, than private law solving the problem. What it tells me is that we have run a bar which seems to suggest that you better go to someone who has power to solve your problem than to go to a professional lawyer. I expect the Ghana Bar to be interested in this aspect of the problem and acknowledge that you cannot be people are losing confidence in lawyers. I speak with my colleagues, and I just came to Attorney General's department. I was doing private practice. One of the biggest problems we all have is that we don't get jobs. Lawyers are not getting briefs. And if you get briefs, they are not quality briefs. The briefs are centralized somewhere for a few people to have, and majority of lawyers are starving and are not getting briefs. I expect Ghana Bar Association to go into this and be interested in solving that. When a petition was brought against the Chief Justice for removal, some of the persons who brought the petition, one of the petitioner was a lawyer, and his petition, the content of the petition, if you assess it, you will see that it's just trying to fight for his rights, as a lawyer. And then the bar is not interested in even supporting their own member who has an issue, and the bar is interested in supporting another interest. So these are the things that inform people members of the bar. When
you say another interest here, you mean the interest of the former Chief Justice?
Well, yeah, clearly they were willing to. In fact, their communique suggested that we should even ignore the constitutional provisions and do something to please the Chief Justice. So, for example, they were saying something that is clearly stated in the Constitution to be in camera, which the Supreme Court has held over and over again to be in camera. The bar communique was telling us that we should ignore it and hold the hearing in public. That has nothing to do with law. That is personal desire. Okay. And my point is that...
But some also argue that it also has to do with the interpretation. And I'm not a lawyer. I'm not going to pretend to be a lawyer.
That's
here.
why I added that.
But
it's not just written as in camera. About three Supreme Court cases,
by Supreme Court
times
decisions.
Say that it is in camera.
Right.
And the bar communique is not saying that the Constitution is wrong. They are saying that in this case, do it this way.
So creating an exemption. So some have suggested the solution to this problem probably to work out a certain legal document that backs what the Constitution says, right? A certain modality around removing the Chief Justice. Is that a possibility? Is that in the working?
The problem is not lack of clarity. It's the same provisions that we have been using since 1992 to remove people, and no one has ever raised issues about clarity. So you see, we can champion personal, desires by using some terminologies to make it look like there's some lack of clarity. There's no, as far as I'm concerned, and the decisions that we've had so far, there's no lack of clarity in any of the processes. But the point I'm making is that in the end, if the bar is doing this, it's not only lawyers who see when there's bias. Ordinary people God has endowed everyone with a conscience to know what is right or wrong, regardless of whether you've gone to law school or not. So if you do this not just once and you do it repeatedly, the perception then becomes clear that, okay, this person, it looks like he's always, when there's a doubt, he goes this way.
One of the occurrences that has fueled this perception has to do with what the Bar Association decides to speak on, depending on who is in government. We heard from the former president of the Ghana Bar Association that perception is not necessarily so. In fact, he explained at the bar conference in Kumasi sometime last year or 2 years ago that it was his personal way of leadership to do things behind the scenes and not necessarily release statements as people had seen in a certain regime or under a certain leadership. Do you think that having a laid down procedure on how the Ghana Bar Association, for example, comments on national issues and issues of national interest can help put the association itself in a way that binds the association to say this is the chosen path, and so regardless of who is president, this is how we choose to speak to national issues? Perhaps that could help in erasing the perception of bias.
I would agree with you, but let me tell you one fundamental thing about organizations and human beings. Every organization, including governments, is just like a vehicle. Depending on the persons or the group of persons who are in control of the vehicle, it doesn't matter what you write, they can drive the vehicle wherever they go. I think that is the situation we seem to be having.
But that would be very interesting because I know that as it stands now, you don't have anything like that says that as a Ghana Bar Association, if we have to comment on national issues, these are the modalities. And so there's nothing binding on any person. But once you agree to a certain methodology, then it will be interesting to see lawyers deviate from that, wouldn't it?
That's why I'm saying that you are right in asking for modalities. And those modalities exist. But
they do exist?
Yes, but let me tell you, every organization is run by democratic principles. So if a majority of people gather today and they say these modalities, let's amend it this way and take this decision, it will happen. That is why I jumped over the modality issue to say that every organization is like a vehicle. Depending on the person driving the vehicle, they can use it to do anything. You can have a government which would respect human rights. With the same laws, another government made of different group of people can use the same laws to oppress the people. So we should be interested in even examining the quality of persons that we put. I think that is how I look at it. And I won't sit here and pretend that Ghana Bar Association is for a particular. If a group of NDC or NDC-oriented lawyers also get a chance to form the majority of Ghana Bar and they're making decisions, chances are that they would also be making communiques that favor,
I need to ask you this question, and you need to answer quickly because you're running out of time, unfortunately. Is it the case then that we are having many lawyers who do not think about national interest, more about party interest and who they're affiliated to? Yes or no?
I think so.
All right. On the issue of the CJ, the removal of the CJ, she's back in court. This time round, seeking to halt the vetting and approval of Chief Justice nominee Paul Bafo-Boni. Surprised? Were you expecting a bit of a toned-down approach? Because we know she's been in court on a number of issues up until her removal, but she's back again. She's not backing down.
Yeah, I mean, it's my trouble because I always have to respond to this, and there's so much work that goes into opposing the Chief Justices,
former Chief Justices.
So when you mention it, my heart just jump, because then it means that I have to now create time to respond to that as well. But I think I'm not surprised because from everything we've seen so far, it should be clear to everyone that the former Chief Justice is not going to let this matter rest anytime soon. So I'm not surprised. I just wish that this will help build the laws that we have in Ghana. We are learning every day, and I'm happy that I'm learning. Apart from the fact that it stretches my time across a wide range of things, I think it's a very good thing, and we should just hope that eventually we will learn and develop our law based on some of the suits that the former Chief Justice is filing.
She's also at the ECOWAS Community Court. The last we heard of, there were concerns about Ghana, responding to that particular suit. What can you tell us about that?
Yes, so we have filed our responses. We are waiting for the court to give a ruling. We objected to the jurisdiction of the court, basically saying that this matter is about the meaning of Ghana's constitution, and no other authority. The ECOWAS court doesn't have the authority, and even according to their own law, They don't have any authority to determine what the meaning of our constitution is, so they do not have the jurisdiction. The court adjourned the matter, I think, in July, and we are waiting for a decision. It was when we were waiting for that decision that we were notified of another application calling on the court to give a judgment in default of defense. What that means is that we didn't file a defense, but we are not bound to file we cannot file a defense when we are challenging the court's jurisdiction. So we responded again, and the court, we are yet to hear from the court what the ruling on these two matters are.
Right, interesting. We've been having a very thorough conversation, speaking about legal education.
A lot of issues.
But one thing I didn't get a response to, though, is about the formation of another bar association or another association of lawyers. You think it's a way to go?
It's actually not a new thing. There are a couple of, I know of other bar associations, just that they are not popular like the GBA.
And they are not recognized by the Constitution.
Yes, the Constitution doesn't mention them as they have mentioned the GBA, and that is one of the legal issues that we have to deal with, because we know the argument is simple. There's freedom of association, which means that no one is bound to belong to one particular association. Two people can form an association, and so the question which comes up is, why is the Constitution recognizing one association over the others, and at the same time recognizing the right to freedom of association? The two appear to be contradictory, because you are saying you can form any association you want and join and practice whatever you want, but you are the same Constitution saying we prefer this association.
Is it a matter of preference, or is it a matter of having a mother body? So, for example, the Ghana Medical Association, the Ghana Registered Nurses and Midwives Association, so you have the Ghana Bar Association, but nothing stops you from forming appendages or...
No, the freedom of association doesn't support the arguments you are making. There's nothing like mother association. It's just another association which people are entitled to join or not to join, and to form their rival or parallel associations, and they are not bound to belong to any association. So, I mean, let's not even drag this. It's a historical issue. At the time the Constitution was being drafted, there were not. I mean, Ghana Bar Association was the only substantive, and the framers of the Constitution intended an association of lawyers that can stand and help in the governance process. In other words, opposing government and the excesses that may come from government. At the time, you couldn't have given it to any other association than the Ghana Bar Association. And if you said that a lawyer of whatever standing, the government is going to just look for 8 lawyers, and appoint to fill the position. We've moved on from there. Now we have all these other associations, and now the new one, I think the new one is the Law Society of Ghana, which also has substantial number of members, and all that. The last time they came for recognition, and they even wanted to have a licensing regime for their own members, just as GBA has. So things are changing, and I believe that when things change, or when things are changing, the laws must also match up, because the original intent is to have a body that can do help in the governance process. Now, that body, we have a couple of them, and so perhaps there will be a time where things will change, and I see that probably happening soon.
We understand the active Chief Justice himself seems to agree with this, and someone has petitioned the President for his removal over speaking openly about it.
It is not even about anyone agreeing. That is the true state of the law. It is a true state of the law. So it is not even an opinion. It is a fact that...
On the petition for his removal is what I want us to focus on.
Well, I don't know the content of the petition, and we are not supposed to know, but I'm sure it will go through the process for a decision to be made. And when that happens, we'll all get to know what exactly the content of the petition is.
But we have seen contents of that petition. That doesn't matter. Does it render Does it render it useless?
I am the second. So my boss is a chief law enforcement officer. I'm the second in command. I will not condone an illegality by first of all looking at the content.
I'm not asking you to affirm it. I'm just saying that does it render it useless?
No, I have to know what it is to be able to know whether it will render it useless.
I mean, the fact that a petition is out there in public.
No, the position of the law is being out there in public doesn't make it void.
Right.
That is what the law says. Being out of there are other remedies for that, but if it's out there in the public, the petition can still be considered, and the outcome could be effective as one that has not been disclosed.
Well, our time is up. I'm really grateful for your company this evening. Thank you for having us, and thank you for touching on issues that matter to a lot of us as Ghanaians. But before I go, though, someone is interested in your style. What informs your style? You and your boss appear to be very stylish.
In terms of
your looks?
Oh, okay. My style?
Your style, yes.
Well, I have been dressing like this for...
what informs it, though?
It's just my preference, nothing in particular. And my boss has been one of the stylish... my boss was my lecturer. And at the time, he was one of the most stylish lawyers, and was very wealthy at the time because he was changing his car. High-end cars every year. And we all looked up to him to become like him. So
probably you don't know...
a rich man for a very long time.
You don't know where the style comes from, but probably you're knowing now. Did he influence you in a way?
Possibly.
Justice Srem-Sai, thank you so much. Thank you for joining me on this edition of State of Affairs. And we have been talking about justice delivery in Ghana. And Justice Srem-Sai has been talking to us. I'm sure some of you are wondering if I was mistaking Justice here. That's his name, Justice. Did that inform your decision to do law?
No. I thought the interview was over, but I can still answer.
Yes, you can.
Maybe I was named, justice was given to me by my mom.
Okay.
My dad wasn't around, I traveled, and so my dad actually wrote a letter indicating how I should be called, and it's not Justice. My mom refused and named me Justice.
Why did she do that? Did you ever find out?
She thought Justice was a better name than the name my dad, and I agree with her.
You do?
Yeah.
You're living out the name.
Yeah.
Thank you so much once again, and good night to you. Thank you for joining us.